Yes? Okay, let's go. Whoever is coming.
Wajackoya is addressing.
Hello.
Yes.
Out?
Yes.
My name is
Okay. Yes. Wajackoya is addressing.
this way.
Yes.
I'm here with my colleagues. This is Ngugi Mburu. This is Ateno Ogola. We were in court today on behalf of our client, Professor Wajackoya, from the directions that the Supreme Court has given, which of course we respect as much as we do not agree with. The Supreme Court has said because he did not file a substantive petition, he is not going to participate in these proceedings directly, except through observation. We believe on behalf of our client that he had been cited as an interested party. We put in our responses on time, we put in our submissions, but all in all, we still respect the court as it is, and we just needed to make a clarification because there's been questions as to why Professor Wajackoya was attending court today. It is because he was actually listed as an interested party in petition 007, that is the Ukiwa Mtata petition, and we actually filed our documents and responses. But regardless of the fact that he did not file a petition, just as per what the learned Honorable Chief Justice has said, a petition under Article 140, the court has locked him out of actively participating in the proceedings. So we are not happy with that, but we will respect the decision of the court. Yeah.
Submissions to be done.
Yeah.
Yeah.
We actually filed in our responses, we filed in our submissions. We believe that those are part of the record of the court, and even when we are not orally addressing the court will still consider those documentations that we file on time. Yeah.
By any chance, was this a lack of filing the petition an omission or just a design that you had no intention at all to file a petition?
No, under the rules of the court and general civil procedure, once you have been listed as an interested party in a petition, we believe that the proper way of disposing of that and ventilating the issues is through filing responses, either supporting or objecting to the petition, as well as filing written submissions with our arguments, which we all did, and they're part of the record of the court, and we believe the court will still take them into account, even though we will not have an opportunity to orally address and highlight them before the Supreme Court.
So as for now, it's only a question of oral submission that you are locked out?
Yes, we've been locked out of oral submissions. As per what the learned Judge Justice Ouko mentioned, only the counsels who will actually be making oral submissions will be in that courtroom. And you heard the learned judge directing our client to even go to the next courtroom, the overflowing courtroom. It means that the court already recognizes his role and his participation in the process. It's just that the submissions, the oral address of the court will not be able to be done, but our documents are still in court.
So to get you clear, you have no intention at all to contest the results?
I don't think whether that's
No.
question.
No, that is not exactly what we are saying.
Yeah.
What we are saying is very simple. We were cited, our client was cited as an interested party, and we put in responses as such. the court will take that into consideration. The decision on whether we should have filed a petition or not is not really something we can talk about at this point.
I think we should direct more questions.
Yeah.
That's fine.
Great.
Zubeida, asante sana, lakini Zubeida, kuna matamshi ambayo yalisemwa na kotini hapa leo wakati Deputy Chief Justice Philomena Mwilu was giving a directive
advocates to abide by what the court says, but we feel the decision was unfair because our position is that our client, Professor Wajackoya, was introduced in this petition as an interested party. In respect of that particular petition, we actually agreed with the petition. We had filed our affidavit in response in respect of the petition. We had also filed our written submissions. We do feel from where we sit that it would have made nonsense of us in such a circumstance where a particular party has already addressed the issues that our client objected to in his petition for us to move again to file a replica petition. That's why we felt it was proper for our client to stand as an interested party, and in fact, the match that we sought from the court was that our client be accorded some little time, even just 10 minutes, to articulate his position in respect of the application of Article 140 of the Constitution, read together with Section 80, subsection 4 of the Elections Act, given the fact that of all the parties in the petition, other than Raila Odinga and William Ruto, if Article 140 is applied to annul the election, our client will be a directly affected party because he will be in that election. If Section 80, subsection 4 is applied such that a direct declaration of the Azimio candidate is reached by the court, our client will also be affected, because that would imply that he would not be seized of the opportunity to have a second bite at the contest of the presidency. So in summation, we agree with the decision of the court. We shall abide with it in as much as we do honestly feel that it was unfair and it denied our client an opportunity to properly articulate these critical issues which directly affect him as a presidential candidate, for whom so many Kenyans voted and for whom, other than that, had a magnetic effect on so many of the Kenyan populace. Thank you.
All right, I have a question.